Okay, I see Mr. Lee and Mr. Pfeiffer. Can you all hear me?
Yes, ma'am.
Yes, Your Honor.
Okay, Mr. Pfeiffer must be here for special appearance. Is the first two?
For Vernon Smith and Julius Clark, Your Honor.
Okay, second two. Okay, we're on the record in the matter of the people of the state of Michigan versus Vernon Smith Jr. File number is 23-01526FY.
No, just in front of the table. Oh, yeah, you got it. Thank you.
Council appearance.
Good afternoon, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Thank you, Your Honor. Assistant Public Defender John Lee on behalf of Vernon Leroy Smith.
Need the date, Mr. Smith, and time set for an arraignment. I have here a felony complaint. It alleges that on or about May 17, 2023 at 1203 West Kalamazoo Street, that's in the city of Lansing, Ingham County, state of Michigan, that you did allegedly, contrary to law, commit the act in count 1 of assault with intent to do great bodily harm, less than murder, or by strangulation. The allegation is that you did make an assault upon a Deandra Embry with the intent to do great bodily harm, less than the crime of murder, or by strangulation or suffocation, and that this is contrary to Michigan Compiled Law 750.84. That's a felony. Maximum penalty, 10 years in prison or $5,000 in fines. Your DNA is to be taken upon arrest, and a consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement. There's a count 2 of domestic violence. It alleges that you did make an assault or an assault and battery upon a Deandra Embry, an individual with whom you had a dating relationship, and that this was done contrary to Michigan Compiled Law 750.812. Restitution may be ordered as this offense may have resulted in damage to another individual's property or physical injury or death to another individual. This is a misdemeanor. The maximum penalty is 93 days in jail and or $500 in fines. Again, a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. There's a habitual offender, third offense notice. It says, take notice that the defendant was twice previously convicted of a felony or attempt to commit a felony in that on or about July 22nd, 1991. He was convicted of the offense of assault with a dangerous weapon in violation of MCL 750.82 in the 17th Circuit Court for Kent County, state of Michigan, and that on or about October 4th, 1994, he was convicted of the offense of assault with a dangerous weapon in violation of MCL 750.82 in the 17th Circuit Court of Kent County, state of Michigan. Therefore, the defendant is subject to the penalties provided under MCL 769.11. That enhances the penalty to twice the maximum sentence on the primary offense or a lesser term. The maximum penalty cannot be less than the maximum term for the first conviction. Mr. Smith, do you understand the charge and the maximum penalty associated with each charge?
I do, Your Honor.
Okay. You have the right to be represented by counsel. You're represented today by Mr. Lee from the Office of the Public Defender. He's here to represent you only for the purposes of your arraignment. You have the right to have an attorney with you to represent you at each stage of the criminal prosecution, and you have the right to have an attorney represent you if you're questioned by law enforcement. If you cannot afford to hire an attorney, you can make a request to have the Public Defender's Office represent you at the expense of the public. Do you understand your right to counsel?
I do.
You have the right in this matter to remain silent. Anything you say, anything you put in writing can be used against you. You have the right to plead guilty. You could plead not guilty, or you can stand mute. You have the right to proceed to a preliminary examination because you're being charged with a felony. And you have the right to have the preliminary examination within 21 days of today's date, because today is the date that you're being arraigned. At the time of your preliminary examination, you have the right to have the prosecution meet their burden, which is to establish that they have sufficient probable cause that a crime was committed and probable cause sufficient to charge you with the crime. If this matter proceeds beyond the preliminary examination, you have the right to a speedy trial. At the time of trial, you have the right to remain silent and not have silence be used against you. You have the right to cross-examine or question any other witnesses that the prosecution intends to call. You have the right to call your own witnesses or present evidence at trial that you believe would further defense to the charges being brought against you. You have the right to have the prosecution prove each element of the charge being brought against you, and they have to prove it at trial beyond a reasonable doubt. Do you have any questions about your trial rights or your rights as it relates to preliminary examination at this time?
No.
Okay. You're currently scheduled for a probable cause conference. It's going to be May 25th, 2023. That's going to be before Judge Stacia Buchanan at 9 o'clock in the morning. You can appear via Zoom or in person for that. Your preliminary examination is scheduled before Judge Buchanan on June 1st, 2023 at 10 o'clock in the morning. That must be in person. Do you have your notice to appear and Zoom instructions yet?
Yes, Your Honor.
Okay. Are you employed?
I am, Your Honor.
Where are you employed?
I'm the sole proprietor of Batch Car Services.
What's your home address?
723 West Shiawassee.
Bless you. That's in Lansing?
Yes.
What's your phone number?
517-619-7062.
Are you currently on probation or parole?
No.
Are you on bond on any other matters that are pending at this time?
No.
Okay.
However, my record was supposed to be expunged as of April, so I don't see how you guys are mentioning stuff from.
Yeah, I don't have any, I can't answer that. You can talk to your attorney about that. For the purposes of his arraignment, how is he pleading, Ms. Julie?
Not guilty, Your Honor.
Okay, the court will enter a plea of not guilty on your behalf. Is he requesting public defense counsel?
Yes, he is.
Okay. Mr. Piper, you can address bond.
Yes, Your Honor. This is a very serious incident, and these are very serious charges. But they do not reflect just how serious this event was. When officers arrived, they found the victim was unconscious and unresponsive, lying on the floor with blood actively pouring from her mouth. They had to roll her on her side so she would not choke on her own blood. They also observed visible blood clots on the floor by her mouth that she appeared to have coughed up, and a pool of blood by her unconscious head. I'll note that once he was arrested, the defendant did tell officers that he was actually the victim and that she attacked him first, though he did not appear to have any injuries. Further, when officers arrived there and he was leaving the scene, he did not comply with the instructions to stop moving quickly away from the officers and to remove his hands from his pockets. Officers actually had to sprint towards him and then later physically remove his hands from his pockets in order to handcuff him because he was refusing to do so. The defendant has prior assaultive convictions, including for felonious assault, and there were children present for this, ages 17 and 12. What's also of concern to my office is that since he was arrested this morning around 3 a.m., he has called the victim 23 times from jail. And when she would not answer because she was still in the hospital, he was getting angrier and angrier, saying things like, if you don't answer this phone, woman, answer this mother effing phone. What the F, you're not answering this phone. And then when she finally did at 11:47 this morning from the jail, he was telling her that this wasn't right, instructing her to come bond him out, and that once they get out together, they will figure out what actually happened here. This is very concerning for my office. That, coupled with the actual observations by the officers and the fact that he did not want to respond to the officers' orders to stop trying to run away from them, the people are requesting $100,000 cash surety, along with GPS tether, victim notification, and exclusion zone. The people also request the no contact order to include the victim's children who are witnesses in this matter, whose names are reflected in the bond form. I feel that that is appropriate for this crime and for the defendant's behavior. Thank you.
Mr. Lee.
Thank you, Your Honor. We would like to remind the court that the prior charges, assault with dangerous weapon and so forth, were from the 1990s. There have been other charges, but they have been dismissed since then. Mr. Pfeiffer does state that Mr. Smith put forward a self-defense argument in this case, and certainly enjoys the presumption of innocence. He is running his own business. He does have significant ties to the community. And so we're asking the court to reconsider a 10% bond for Mr. Smith that he might be able to post bond at some point in this case.
Based on the excuse me, information provided by both the affidavit of probable cause, but also the prosecutor, the court does have overwhelming concern for the safety of the victim as well as the public. I believe that the request for $100,000 cash surety bond is appropriate. Bond will be set at that amount, $100,000 cash surety with GPS tether and victim notification. I'm going to order that the victim's number be blocked while the defendant is in the custody of the jail. I'm going to also order that there's a no contact order in place protecting Ms. Deandra Embry and the two minors listed here in the complaint. Mr. Smith, you're not to be within 1,500 feet of wherever they live, work, go to school, go grocery shopping, worship in church, do their laundry, anything else. You're not to be within 1,500 feet of them. Do you understand that?
I do, Your Honor.
You're not to have contact directly or indirectly with him. Do you understand that?
I do, Your Honor.
Do you understand what direct contact means?
Conversation, telephone calls, direct contact. I do understand.
Okay. Well, give me some examples of indirect contact.
Indirect contact,
Correct.
walking past her.
Or having someone else. You can't have any third party contact. You can't use anybody else to deliver a message on your behalf. You can't call from another particular inmate's number to contact her. There's not to be any communication of any kind during the pendency of this matter. Do you understand that?
That's fine.
You need to make sure you appear to all of your court dates. You've been provided your next 2 court dates at this time. You're not to travel outside of the state unless you get prior approval from the court. You're not to possess a firearm or any other dangerous weapon. You're not to use, purchase, or possess drugs or alcohol while on bond unless you have a valid prescription. You're not to engage in any assaultive or threatening behavior. You need to report to pretrial services within 48 hours of release from custody. You'll be reporting to them weekly. Do you have any questions about your bond conditions?
I do not. $100,000. For assault. That's insane.
I'm going to remind you again of your right to remain silent, okay?
Yes, Your Honor.
Any additional matters for the record, counsel?
Not from the people.
Nothing for the defense. Thank you, Your Honor.
You're all set, Mr. Smith.
All right, thank you.
We're on the record in the matter of the people of the state of Michigan versus Julius Clark, file number 23-01528 FY, counsel appearance.
Good afternoon, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Thank you, Your Honor. Assistant Public Defender John Lee on behalf of Julius Lee Clark.
Today's the date Mr. Clark set for arraignments. I have here a felony complaint that alleges that on or about May 16, 2023, at 304 at Lathrop Street, City of Lansing, Ingham County, State of Michigan, that you did allegedly in count 1 commit the act with assault with intent to murder. It alleges that you did make an assault upon a Christina Childress with the intent to commit the crime of murder, and that this was contrary to Michigan Compiled Law 750.83. It's a felony. The maximum penalty is life for any number of years. Your DNA is to be taken upon arrest, and a consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement. There's a count 2 of assault with intent to do great bodily harm less than murder or by strangulation. The allegation is that you did make an assault upon a Christina Childress by strangulation or suffocation, and that this is contrary to Michigan Compiled Law 750.84. That's a felony. The maximum penalty is 10 years in prison or $5,000 in fines. Your DNA is to be taken upon arrest, and a consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement. There's a count 3 of domestic violence. It alleges that you did make an assault or assault with battery upon a Christina Childress, a resident or former resident of your household, or an individual with whom you had a dating relationship, and that this is done contrary to Michigan Compiled Law 750.812. restitution may be ordered as this offense may have resulted in damage to another individual's personal property or physical injury or death to another individual. This is a misdemeanor. Maximum penalty is 93 days in jail. Excuse me, and or $500 in fines. A consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. But there is a second offense notice. It says, take notice that the defendant was previously convicted of assaulting or assaulting and battering his or her spouse, former spouse, an individual with whom he had a relationship, a dating relationship, an individual with whom he had a child in common, or a resident or former resident of his household, or of knowingly assaulting a pregnant individual by violating Michigan Compiled Law 750.81A2 on or about March 22nd, 2017, and therefore upon conviction will be subject to an enhanced sentencing under MCL 750.814. That makes the maximum penalty a misdemeanor, 1 year and or $1,000 in fines, and a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. You understand the 3 counts, second offense notice, and the maximum penalty associated with each.
Yes.
Okay, you have the right to be represented by counsel. Mr. Lee is here to represent you solely for the purposes of your arraignment, but you have the right to have an attorney with you to represent you at every stage of the criminal prosecution, and you have the right to have an attorney represent you if you're questioned by law enforcement. If you cannot afford to hire an attorney, you can make a request to have the public defender's office represent you at the expense of the public. Do you understand your right to counsel?
Yes. Yes, Your Honor.
You have the right to remain silent. Anything that you say, anything you put in writing can be used against you. You have the right to plead guilty. You have the right to plead not guilty, and you can stand mute and will continue to trial on this matter. You're being charged with felonies in this matter, so you have the right to have a preliminary examination. And you have the right to have the preliminary examination within 21 days of today's date. Today's date being the date of your arraignment, okay?
Yes, ma'am.
At the time of your examination, you have the right to have the prosecution put forth evidence to establish that they have probable cause that a crime was committed and sufficient probable cause to charge you with the crime. If this matter proceeds beyond the preliminary examination, you have the right, sir, to have a trial. At the time of trial, you have the right to the presumption of innocence. So you're innocent until proven guilty. You have the right to remain silent at trial and not have silence be used against you. You have the right to see, hear, or question any other witnesses the prosecution intends to call. You have the right to call your own witnesses to trial, or present evidence at trial that you believe furthers a defense to these charges. You have the right to have the prosecution prove each element of the charge being brought against you at trial beyond a reasonable doubt. Do you have any questions about any of these rights so far?
No, ma'am.
You have the right to be considered for pretrial release from custody. We'll address your bond in just a moment. Are you employed, sir?
I am.
Where are you employed?
I work for EQS, third party inside of Bridgewater.
What's your home address?
5017 Connors Avenue.
1517, what?
5017 Connors Avenue.
Is that in Lansing?
Yes, ma'am.
What's your phone number?
517-885-8319.
You're currently scheduled for a probable cause conference before Judge Stacia Buchanan, May 25th, 2023 at 9 o'clock in the morning. You can appear via Zoom or in person for the probable cause conference. You have a preliminary examination before Judge Buchanan. It's June 1st at 10 o'clock in the morning. Did you get a copy of your notice to appear and her Zoom instructions?
Yes, ma'am.
So Are you currently on probation or on parole?
No, ma'am.
Are you out on bond or any pending matters?
No, ma'am.
How you gonna address bond counsel? Mr. Piper?
Thank you, Your Honor. The defendant is charged with incredibly serious violent crimes involving domestic violence. The defendant had sent the victim threatening text messages before arriving at her place, and when the victim wasn't responding because she was asleep, he went to her home, and upon being let in by her minor child, he started to attack her while she was asleep in her bed. He strangled her multiple times, and she nearly blacked out each of those times. She shouted for her child to call the police, at which point he started beating her in the head and face. When the child said he was going to call the police, the defendant began to run after her 14-year-old child. It got to the point where the victim had to actually fire off a gun in the defendant's direction in order to protect herself and her child, because he would not leave and he would not stop attacking them. The defendant fled the scene. When police responded and were speaking with the victim about what happened and were trying to locate the defendant was calling the victim, and officers overheard the defendant make multiple threats to kill not only the victim, but her children as well. Once again, that is not a statement from the victim. That was directly overheard by the officers. The defendant has a history of violence against this victim. He also has a history of violating personal protection orders with this victim. He admitted guilt to such violation, was sentenced to 7 days in jail earlier this year. Because of all of this, and particularly the threats to murder her and her children, my office is deeply concerned about the safety to the victim, her children, and the public at large by this defendant. My office is requesting $250,000 cash surety, GPS tether, victim notification, and an exclusion zone. And we ask that the no contact order include the minor child witness, whose name is included in the report and the bond report. Thank you.
Mr. Lee, is your client entered a plea of not guilty?
Yes, Your Honor.
He's requesting public defense representation.
Yes, Your Honor.
Okay, you can proceed.
Thank you. Your Honor, these allegations are just that, they're allegations. Nothing has been proven yet. Mr. Clark enjoys the presumption of innocence in this case. He does have one prior offense. However, this particular case seems to be limited to an interaction with one particular individual. We believe the court can institute measures that will protect the complaining witness without imposing a $250,000 bond. We would ask the court to consider a 10% bond of some sort that would allow Mr. Clark at least a chance of being able to post bond.
reviewed the defendant's prior criminal history. I do see at least one other assaultive conviction. Excuse me, and in review of the affidavit of probable cause, as well as the information provided by the prosecution, I do believe that there is a concern for the safety of the victim and to the public. Don't know that a $250,000 bond is necessary, but I do believe that the court needs to fix a bond appropriately situated to protect and ensure the protection of the alleged victim. With that being stated, bond will be set in the amount of $75,000 cash surety with GPS tether. And victim notification. You're not to be within 1,500 feet of the victim in this matter or her minor child. You're not to have contact directly or indirectly with the victim in this matter. Do you understand what that means?
Yes.
You're not to have third-party contact or communication of any kind by any means or mechanism with the victim or the victim's child. Do you understand that?
Yes, ma'am.
While out on bond, you need to make sure you report to all of your future court dates. You're not to travel outside the state without prior approval of the court. You're not to possess a firearm or any other dangerous weapon. You're not to engage in any assaultive or threatening behavior. You need to report to pretrial services within 48 hours of your release. You'll be reporting to them weekly.
Yes, ma'am.
Do you have any questions about your bond?
I'm sorry, how much is it again?
75,000 cash surety.
So that means that I have to pay the whole 75?
You get a bondsman, sir.
Okay. No, that's it.
Okay. Any additional matters for the record, counsel?
I just want to make sure there was going to be an exclusion zone around the victim's address as part of the tether.
That is correct. We put that he's not to be within 1,500 feet of wherever she is, and that will include her address.
Thank you. The tether company sometimes doesn't view that language as an exclusion zone. That's why I want to make sure.
Oh, no, we would put on our bond wherever she lives, works, or goes to school.
Perfect. Thank you, Your Honor.
No problem. Any additional matters?
Not from the people.
Nothing for the defense. Thank you, Your Honor.
Thank you. You're all set, Mr. Clark.
Thanks.
That is it from me. Thank you very much, Your Honor.
Thank you.
Have a good rest of your
On the
day.
record- Same to you. We're on the record in the matters of the people of the state of Michigan versus Angelo Williams. I have 3 files, file numbers 23-01521FY, 23-01523FY, and 22-00650FY. Council appearance.
I'm sorry, Your Honor. Who is this for?
Angelo Williams.
Oh, gotcha. Thank you. Assistant Public Defender John Lee on behalf of Angelo Williams.
Okay, let's see, Mr. Williams, starting with file number ending in 521. I have a felony complaint here. It alleges that on or about April 30th, 2023, at the area of 3308 South Cedar Street, City of Lansing, Ingham County, State of Michigan, that you did allegedly, contrary to law, commit the act in count 1 of an assault with intent to murder. The allegations is that you did make an assault upon a D'Angelo Johnson with the intent to commit the crime of murder, contrary to MCL 750.83. That's a felony, sir. The maximum penalty is life for any number of years. Your DNA is to be taken upon arrest, and a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. There's a count 2 of assault with a dangerous weapon. That's also called felonious assault. The allegation is that you did make an assault upon a D'Angelo Johnson with a dangerous weapon, that being a firearm, but without intending to commit the crime of murder or to inflict great bodily harm less than the crime of murder. This is contrary to MCL 750.82. That's a felony. Maximum penalty is 4 years and or $2,000 in fines. Your DNA again is to be taken upon arrest, and a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. There's a count 3 of weapons, firearms, possession by felon. It alleges that you did possess or use or carry a firearm when ineligible to do so, because you have been convicted of controlled substance possession less than 25 grams, which is a specified felony that is punishable by imprisonment of 4 or more years, and the requirements for regaining eligibility had not been met. This is contrary to MCL 750.224F. It's a felony. The maximum penalty is 5 years and or $5,000 in fines, and there's a mandatory forfeiture of the weapon or device required under the law. Count 4 is weapons, felony firearm. It alleges that you did carry or have in your possession a firearm, that being a pistol, at the time that you committed or attempted to commit the felony of assault with intent to murder, contrary to MCL 750.227B. That's a felony. Maximum penalty 2 years consecutively with and preceding any term of imprisonment imposed for the felony or attempted felony conviction, and there's a mandatory forfeiture of the weapon or device required under the law. Count 5 again is a weapons, felony firearm, alleging that you did carry or have in your possession a firearm, that being a pistol, at the time that you committed or attempted to commit the felony of assault with a dangerous weapon, also known as felonious assault, contrary to MCL 750.227B. Count 6 is again another weapons, felony firearm, alleging that you did carry or have on your person a firearm, that being a pistol, when you committed or attempted to commit the act of weapons, firearms possession by felon, contrary to MCL 750.227B. Count 5 and 6 again are felonies. Maximum penalty 2 years consecutively with and preceding any term of imprisonment imposed for the felony or attempted felony conviction. There is a mandatory forfeiture of the weapon or device required under the law. Do you understand all the charges in that file and the maximum penalty?
Yes.
File number ending in 523. I have a felony complaint. It alleges that on or about May 16, 2023, at the area of 3304 North Waverly Road, City of Lansing, Ingham County, State of Michigan, that you did allegedly, contrary to law, commit the act in count 1, weapons, carrying concealed. It alleges that you did carry a dangerous weapon, that being a pistol, concealed on or about your person, and that this was done contrary to MCL 750.227. This is a felony. Maximum penalty 5 years or $2,500 in fines, and there's a mandatory forfeiture of the weapon or device required under the law. There's a count 2 of weapons, firearms, possession by felon. It alleges that you did possess or carry a firearm when ineligible to do so, because you have been convicted of controlled substance possession of cocaine, heroin, or other narcotic less than 25 grams, a felony punishable by imprisonment of 4 or more years, and the requirements for regaining eligibility had not been met, contrary to MCL 750.224F. Again, that's a felony. The maximum penalty is 5 years and or $5,000 in fines. There's a mandatory forfeiture of the weapon or device under the law. Count 3, police officer assaulting, resisting, obstructing. Alleges that you did assault, batter, wound, resist, obstruct, oppose, or endanger Officer James Zolni and or Sergeant Wesley Bond, police officers of the Lansing Police Department that the defendant knew or had reason to know was performing his or her duties, and that this was done contrary to Michigan Compiled Law 750.81 D1. That's a felony. The maximum penalty is 2 years and or $2,000 in fines. A consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement, or under MCL 750.81 D6 for another violation arising from the same transaction. There is an habitual offender second offense notice that alleges or states that take notice that the defendant was previously convicted of the felony or an attempt to commit a felony, and that on or about June 16, 2021, he was convicted of the offense of controlled substance possession of cocaine, heroin, or other narcotic less than 25 grams in violation of Michigan Compiled Law 333.74032A. 5 in the 30th Circuit Court, Ingham County, State of Michigan. Therefore, the defendant is subject to the penalties provided by MCL 769.10. That increases the penalty to 1 1/2 times the maximum sentence on the primary offense or a lesser term. The maximum penalty cannot be less than the maximum term for the first conviction. Do you understand your rights and the maximum penalties? I'm sorry, do you understand the charges and the maximum penalties in that file?
Yes.
Okay, in each of these files, sir, you have the following rights. You have the right to be represented by counsel. Mr. Lee is representing you just for the purposes of your arraignment today, but you have the right to have an attorney with you to represent you at each stage of the criminal prosecution. You have the right to have an attorney represent you if you are questioned by law enforcement. If you cannot afford to hire an attorney, you can request to have court-appointed counsel represent you at the expense of the public. Do you understand that?
Yes.
Is he making a request for court-appointed counsel?
Yes, he is, Your Honor.
You have the right to remain silent, sir. Anything you say, anything that you put in writing can be used against you. You have the right to plead guilty. You can plead not guilty, or you can stand mute. You have the right in this matter, in these files, to proceed to preliminary examination because you're being charged with felonies in each file. In each file, you have the right to have a preliminary examination within 21 days of your arraignment unless good cause is found to go beyond that 21 days, or if you waive the 21-day timeline. At the time of preliminary examination, you have the right to have the prosecution meet their burden of probable cause. So they have to establish that they have sufficient probable cause that a crime was committed and sufficient probable cause to charge you with the crimes. Do you understand your rights so far?
Yes.
Your Honor, I need to interject here. I misspoke. I said that he had made an application for the public defender. He did not make an application for the public defender and has expressed a desire to hire his own attorney.
Okay, sounds good. That is correct, sir?
Yes.
Okay, Mr. Williams, if this matter proceeds to a beyond the preliminary exam stage, you have the right to have a trial. At the time of trial, you have the right to the presumption of innocence. So you're innocent until proven guilty. You have the right to require the prosecution to prove your guilt at trial by proving each element of the charge being brought against you, or the charges being brought against you, beyond a reasonable doubt. You have the right to remain silent at trial and not have silence be used against you. You have the right to see, hear, or question any witness being brought against you at a trial. You have the right to call yourself or to call other witnesses at trial or present evidence at trial that you believe would further a defense to these charges. Do you understand each of those rights?
Yes.
You have the right to have the prosecution prove each other beyond a reasonable doubt at trial. And you have the right to be considered for release on bond pending this prosecution. We'll address your bond in just a moment. Let's get your updated address, sir. What is your home address?
941 McCullough Street.
Give it to me again.
941 McCullough Street.
In Lansing?
Yes.
What's your phone number?
773-930-1953.
One of these files has an incorrect address, I think. 523, so have the correct address. File number ended in 523 because I have his correct address. But for the purposes of his arraignment, how is he pleading?
Not guilty, Your Honor.
Are you employed, sir?
Not anymore.
Okay. Okay, in both of these files, you're scheduled for probable cause conference before Judge Cynthia Ward, Friday, May 26, 2023 at 8 o'clock in the morning. You have preliminary examination scheduled on June 2nd before Judge Ward at 9 o'clock in the morning in both of these files. You can appear for probable cause conference via Zoom or in person. However, you must appear in person for your preliminary examination, okay?
Yes.
Did you get your notice to appear? I didn't hear you.
Yes, I got it.
Are you currently on probation, parole, or on bond?
No.
That's funny. I have a probation violation arraignment here.
I
That's why I asked that question. I wanted to see if you were going to tell me the truth.
I'm saying I'm not, no, I got a violation for it.
You're on probation before Judge Ward. I have here a request and summons for a probation violation. It alleges that you violated the terms of your probation before Judge Ward by failing to report to the probation officer monthly back in July 2022 that you failed to pay fines and costs, the amount due of $485, and that you failed to begin your testing on June 22nd, 2022, as I'm having a struggle reading these people's handwriting, as required, I presume is what this says, on June 13th, 2022. And so you were supposed to appear for arraignment on the probation violation back on November 29th, 2022 at 1:30. You failed to appear. Judge Ward placed you on probation. Looks like on May 27th, 2022. So you have the right to have a contested hearing. You have the right at the time of the contested hearing to be represented by counsel. If you are found to be in violation of your probation status, and again, at the time of the contested hearing, you have the right to have the prosecution and the probation put forth evidence to establish whether or not you violated your probation terms as alleged. If you are found to be guilty of the violations, your probation status can be revoked. You can be sentenced to a term of jail time. Your probation can be extended or continued. You can have other oversight such as a tether attached or other programming ordered as a requirement of your probation conditions. Do you understand that? Or do you want to plead as to the violations of the probation?
Not guilty, Your Honor.
Okay, and to plead not guilty for your probation violations. Bond counsel.
Thank you, Your Honor. Mr. Smith, Mr. Williams has lived here in the Lansing area for approximately 10 years. He has family here, he has children here, he has significant ties to the community. And though he has been convicted of possession of controlled substance, his prior convictions are mostly of a nonviolent nature. We're asking the court to consider that in light of the very serious charges that he is currently facing, and set a bond of 10% nature that would allow him an opportunity to post a bond and or a low cash surety bond in the alternative.
Okay. Mr. Williams, you are facing some very serious charges, although not necessarily violent in nature. They're very serious. She's got 2 pending files, both one with 6 counts, and the other you have 3 counts and an habitual offender notice, and then you also have a probation violation that's pending. So that means you were on probation at the time of these alleged incidents. The other concern is that even with the probation violation and the address that you provided me today is the same address on the probation file. So that means that your notices would have been sent to the accurate address. Nonetheless, you failed to appear and have been absconding from your probation status for more than 6 months. The allegations in the probation violation by nature that you failed to make any progress or do what you were ordered to do by the court. So the court does have a concern that you are willing or are able to follow court orders. And so because of that, I question your ability to return to court unless a bond is fixed appropriately to ensure your return. With that being said, for the bond violation, your bond is set at $5,000, 10%. And in that file, you're scheduled to see Judge Ward on June 5th at 1:30 for your hearing on probation violation. On file number ending in 1521, bond is set at 10,000 cash surety. File number maybe then 523. Bond is set at 10,000 cash surety. While out on bond in both files, you have the following conditions. You need to report to all of your court dates, sir. You're not to travel outside the state without prior approval of the court. You're not to use, purchase, or possess any drugs or alcohol unless you have a valid prescription. You're not to possess a firearm or any other dangerous weapon. You're not to engage in any assaultive or threatening behavior. You need to report to pretrial services within 48 hours of your release. You'll be reporting to pretrial services weekly. Do you understand that?
Yes.
Do you have any questions about your bonds in each file?
No, ma'am.
Any additional matters from the record, counsel? Oh, one question. Spell your middle name, sir.
ANTWUAN.
Thank you. Any additional matters for the record, counsel?
Nothing further. Thank you, Your Honor.
You're all set, sir. On the record in the matter of the people of the state of Michigan versus William Cooper, file number 23-01529 FY, counsel appearance.
Assistant Public Defender John Lee on behalf of William Anthony Cooper.
Okay, Mr. Cooper, today is the date and the time that's set for an arraignment. I have here a felony complaint that alleges that on or about May 16, 2023, at the area of 1529 Bailey Street, City of Lansing, Ingham County, State of Michigan, that you did allegedly, contrary to law, commit the act in count 1 of home invasion first degree. The allegation is that you did break and enter or did enter without permission a dwelling located at 1529 Bailey Street, Lansing, with the intent to commit an assault therein, and while entering, present in, or exiting the dwelling, a Tierra Denise Louise Cooper was lawfully present therein, and that this is contrary to Michigan Compiled Law 750.11082. That's a felony. The maximum penalty is 20 years in prison and or $5,000 in fines. A consecutive sentence may be imposed for any other conviction arising from the same transaction. Do you understand the charge and the maximum penalty, sir?
Yes, ma'am.
Okay, you have the right to be represented by counsel, Mr. Do you understand the charge, sir? I don't think it picked
Yes,
up on
ma'am.
the. Okay, you have the right to be represented by counsel. Anything you say, I'm sorry, Mr. Lee is here to represent you for the purposes of your arraignment only. And so you have the right to have an attorney represent you at each stage of the prosecution and if you're questioned by law enforcement. If you cannot afford to hire an attorney, you can request to have the public defender's office represent you at the expense of the public. Do you understand that?
Yes, ma'am.
Is he requesting public defense representation?
Yes, he is, Your Honor.
You have the right to remain silent. Anything you say, anything you put in writing can be used against you. You have the right to plead guilty, sir. You have the right to plead not guilty, and you have the right to stand mute. You have the right in this matter to proceed to preliminary examination within 21 days of today's date. At the time of your preliminary examination, you have the right to have the prosecution put forth evidence to establish whether or not they have sufficient probable cause that a crime was committed and probable cause sufficient to charge you with the crime. Do you understand those rights?
Yes.
Okay, if this matter proceeds beyond preliminary examination, you have the right to a trial. And you have the right to the presumption of innocence at trial. So you're innocent until proven guilty. You have the right to have the prosecution prove your guilt at trial by proving each element of the charge being brought against you beyond a reasonable doubt. You have the right to see, hear, or question any of the witnesses that the prosecution intends to call. You have the right to call your own witnesses to trial or present evidence at trial that you believe would further defense the charge. You have the right to remain silent at trial and not have silence be used against you. You understand those rights?
Yes, ma'am.
Okay. You have the right to be considered for pretrial release from custody. We'll address your bond in a moment. For the purposes of his arraignment, is he pleading not guilty?
Yes, Your Honor.
Are you employed, sir?
Yes, ma'am.
Where are you employed?
I work for Quality Building Services.
What's your home address?
1119 Leslie Street.
That's in Lansing?
Yes, ma'am.
What's your phone number?
517-894-3482.
You're currently scheduled for probable cause conference before Judge Stacia Buchanan. It's gonna be Thursday, May 25th, 2023 at 9 o'clock in the morning. You have a preliminary examination scheduled on Thursday, June 1st, 2023 at 10 o'clock in the morning before Judge Buchanan. You can appear for probable cause conference via Zoom, but you have to appear in person for the preliminary examination, okay?
Yes.
Did you get your notice to appear in the Zoom instructions?
Yes, ma'am.
Are you currently on probation or on parole?
No, ma'am.
Are you on bond in any other matter at this time?
No, ma'am.
Counsel, you can address bond.
Thank you, Your Honor. Defendant, Mr. Cooper, reports only one prior charge, what was dismissed. So he does not have a record that would indicate that he is a danger to himself or society. He's lived in Lansing most of his life. He has a child here in Lansing, lives with his mother here in Lansing. So his support structure and his family is all here in Lansing. We're asking Your Honor to consider a personal recognizance bond for Mr. Cooper in this matter.
Allegations as alleged would indicate that if true, Mr. Cooper was in violation of an active personal protective order, which would cause the court to have concern for the safety of the victim. I'll grant the request for a personal recognizance bond, but it will be with GPS tether and victim notification. So bond will be set in the amount of 5,000 personal recognizance with GPS tether. You're not to be within 1,500 feet of the victim. That's wherever the victim is, but specifically where she lives, works, or goes to school. Do you understand that?
Yes, ma'am.
You have to have contact directly or indirectly with the victim. Do you understand that?
Yes, ma'am.
You hesitated as if you needed to think about your understanding of that.
No, I was just thinking like I didn't get served a PPO until I got here.
Okay, so do you have a question about the PPO? Is that what the question was?
No, I was just saying, you saying I violated it, but I didn't get served it until I got to.
I said the allegations were that you violated. That's
Oh,
the
okay, I'm
allegations.
sorry.
I don't know if you did it or not. I wasn't there. I can just tell you what was put in the affidavit of probable cause. And one of those is that you indicated your knowledge of a personal protective order and that you were not to be at that address. And so whether or not that's true, that's for you and your attorney to determine and for you to use if necessary at the time of, when it's time for you to put forth a defense. But now is not the time to put forth a defense, okay? But do you have any questions about the no contact order? Just that's the time for you to ask questions about that.
No, ma'am.
Okay, so you're not to have third-party contact, you're not to have contact directly or indirectly, you're not to be within 1,500 feet of the victim. You're not to be at the address of (1529) Bailey Street, City of Lansing, okay? Okay?
Yes.
You're not to engage in any assaultive or threatening behavior. You're not to purchase or possess a firearm while on bond. You're not to use or purchase or possess any alcohol or drugs unless you have a valid prescription. You need to report to pretrial services within 48 hours of your release, okay?
Yes, ma'am.
Do you have any questions about any of your bond conditions?
No.
Any additional matters for the record, counsel?
Nothing further, Your Honor.
Okay, you're all set, sir. On the record in the matters of the people of the state of Michigan versus Jamie Jesus Soto, file number 22-00036. And they also have the state of Michigan, people of the state of Michigan versus Jamie Soto, file number 19-05088 SD. Council appearances, please.
Assistant Public Defender John Lee on behalf of Jamie Jesus Soto.
Okay, Mr. Soto, today is the day that we're addressing these two files because file number ending in 0036. You were supposed to appear before me back on September 12th at 8:30 for final pretrial, and then for a trial, it looks like on actually before Judge Flores. It's just because my handwriting in this file. He was supposed to appear before Judge Flores back on September 12th at 8:30, and then on September 26th at 8 a.m. for jury trial. You failed to appear. Did you forget about your trial?
No, ma'am.
Okay, why did you not appear?
But when I went on that time, that person that's at the front counter told me that I wasn't on the list. When I gave him the paper to the, he said I wasn't on the list, so I just left.
The person was at what counter?
Right when you get off the elevator to go up.
You mean the security officer, or did you go to the criminal traffic window?
No, the security officer, right when you get off, because he asked me which room I was looking for, and I gave him my paper, and he looked at some list, and he said I wasn't on there.
Your matter's been reset for pretrial before Judge Flores. It's gonna be June 6th at 9:30, okay? As to the other file, file number 19-05088, you owe $1,134.25. I referred you to collections back on August 10th, 2022 to make a payment plan, but you never did it.
Yes, ma'am.
Did
Well, I
you
didn't
forget
have,
about that? Or
No, ma'am.
did the security tell you that you were not on the list?
Oh, ma'am, I didn't have a job. I just barely got a job. I barely started working. I'm homeless at the moment.
Well, you owe a large amount of restitution for drunk driving, sir. So when are you gonna, and how are you gonna pay that?
As soon as I get back on my feet, start making payments.
You're gonna make a payment now, otherwise we don't know how to fix your bond.
Right now, I don't have no money. I just started working. I don't get paid till Friday, this Friday coming
Where
up.
do you work?
KFC,
Which KFC?
the one on South Cedar, American Road.
How long have you been working there?
Just barely started a week ago. This was my second week.
Are you working full time?
Yes, ma'am.
Okay. And so you're gonna create a payment plan today. I'm not gonna leave and let you report to probation, I'm sorry, to collections, because we did that last time and you didn't. And so when are you
Yep.
gonna make your next payment?
I can make a little payment this Friday.
How much are you gonna pay?
100.
And you're certain you can afford $100 this Friday?
Yes, ma'am.
When are you gonna make your next payment?
Next paycheck, I'll see what I can start affording.
Okay, you make a payment of $100 on Friday, you'll make your next payment 30 days from that of another $100, okay?
Yes, ma'am.
If you need a reduced amount, you need to come back to the court and request it, okay?
Yes, ma'am.
You can't just not address it and blow it off, because that's how you get warrants, and then you end up sitting in jail instead of at your job, and then that's how you lose your job, and that's how the cycle of homelessness continues. You understand that?
Yes, ma'am.
So grow up and take care of your responsibilities.
Yes, ma'am.
What's your phone number?
I don't have one at the moment.
And you say you're homeless, so there's no
Yes,
place for
ma'am.
you to receive mail,
No, ma'am.
but we notify you at KFC on South Cedar though, correct?
Yes, ma'am.
Okay. You received your notice to appear for your next court date before Judge Flores, correct?
Yes, ma'am.
I set your bond at $1,000 personal recognizance, not because I trust that you're gonna return on your personal recognizance, but I would rather see you go to your job and get your paycheck on Friday. But I can guarantee you, I'm nicer than Judge Flores when it comes to setting bonds. So if you don't show up this time, he's not gonna give you a personal recognizance bond, okay?
Yes, ma'am.
All your previous bond conditions, which were set back on August 10th, 2022, will continue. You're not to engage in any assaultive or threatening behavior. You're not to purchase or possess drugs or alcohol without a valid prescription. You're not to purchase or possess a firearm or any other dangerous weapon. There's a no contact order in place protecting the alleged victim, Sierra Medina. I don't see where there's been any allegations of violation, so that is a good thing in your favor. You need to report to all of your court dates. Okay, sir?
Yes, ma'am.
If you have a court date that says you're supposed to be here, you need the judge to tell you that you're not supposed to be here, okay?
Yes, ma'am.
You also have an attorney, is that correct?
Yes,
No,
ma'am.
Yes.
Do you know what your attorney's name is?
No, ma'am.
Who's this attorney?
Aaron Robinson.
Okay, Aaron Robinson is your attorney, so when you come to court on June 6th, you need to be making sure, if you haven't spoken with her beforehand, which I'm inclined to believe that won't happen since you don't have a phone number for her to contact you, you're gonna need to get here early so she can talk to you, okay?
Yes, ma'am.
You're gonna need to make sure you talk to your attorney and not to the security, okay?
Yes, ma'am.
Do you have any questions?
No, ma'am.
Any additional matters for the record?
Nothing further, Your Honor.
You're all set, sir. Thank you. On the record in the matter of the people of the state of Michigan versus Tyler Bunkley, file number 20-02272 and 21-00071. Council appearance.
Assistant Public Defender John Lee on behalf of Tyler Bunkley.
Okay, Mr. Bunkley, today's the date and the time that's set. For an arraignment, file number ending in 272. It's here because you failed to make payment on your fines and costs. Looks like you owe $625. You were on probation before me previously. I discharged you unsuccessfully because you would not comply, and I referred the balance to collections. You were also on probation before Judge Aquilina at the time, and I believe attempting to get into the Veterans Court. Nonetheless, you never took care of these fines and costs. What's going on with that?
I went through a period of homelessness, lost my vehicle and my license and everything at that time.
Okay, and what period are you in now?
I just started working Monday. I'm in the homeless shelter. Things are looking up.
Are you still on probation before Judge Aquilina?
Yes, ma'am.
Where are you working?
I do lawn care.
Do lawn care where?
It's my friend's business at Kwan Clay.
Are you working full-time?
Yes, ma'am.
When are you gonna make your payment on these fines and costs?
I can start as early as next month.
How much you gonna pay?
I can pay 50 at a time.
What day next month are you gonna make this payment?
I'll look for like at the first Friday of the month. I'm not sure what day that is though.
June 2nd?
Okay.
I'll note here, you'll make a payment of $50. On June 2nd, you'll make payments of $50 at the first Friday of each month until paid in full, okay?
Yes, ma'am.
If you don't make payment, what's gonna happen?
Jail.
That, and then you'll still have to make payment. So you might as well make the payment, right?
Yes, ma'am.
You have a PA 53 violation, which is a bond violation. However, this is a matter that's before the circuit court. What is the charge? I don't even know what the file is. Do you know? Did you buy something over? You have a court date before Judge, before the circuit court, that is? Are you on bond with the matter in the circuit court right now?
I'm not sure. I know I was when I was on misdemeanor, but they told me I didn't have to call or whatnot, and told me to stay out of trouble.
File number 21-0007. It was set by Judge Simmons. Okay, and you don't know if you have a court date or pending
For which-
open matter in circuit court right now for an assault and battery? What was the felony in there? Or larceny?
Is that the misdemeanor or the felony?
Was sentenced? Alert cancel condition upon re-cancel. So, you're confused with what to do. Okay. I think the matter with which this PA 53 violation on is one that you pled guilty to interfering with an electronic communications. Does that refresh your recollection?
Yes, I'm on probation for that now.
Before whom?
Aquilina, I believe.
Okay, well, you'll be remanded to see her because this file is before her, not before the 54A District Court. Any additional matters for the record today?
Nothing further, Your Honor.
You're all set, sir.
Thank you.
We're on the record in the matter of the people of the state of Michigan versus Anthony Zaria. File number is 23-01530. Council appearance.
Assistant Public Defender John Lee appearing on behalf of Anthony Carr Zarwia.
Okay, Mrs. Zaria, today's the date and the time set for an arraignment. I do have a misdemeanor complaint here. It alleges that on or about May 17, 2023, at the area of 1925 West Holmes, Apartment 10, City of Lansing, Ingham County, State of Michigan, that you did allegedly contrary to law commit the act in count 1 of domestic violence. It alleges that you did make an assault or assault and battery upon a Nancy Solo, an individual with whom you had a child in common, or resident or former resident of your household, or an individual with whom you had a dating relationship, and that this was done contrary to Michigan Compiled Law 750.812. Restitution may be ordered as this offense may have resulted and damage to another individual's property or physical injury or death to another individual. This is a misdemeanor with a maximum penalty of 93 days in jail and or $500 in fines. A consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. Do you understand the charge, sir, and the maximum penalty attached to the charge?
Yes.
Okay, you have the right to be represented by an attorney. Mr. Lee is representing you for the purposes of your arraignment only. You have the right to have an attorney represent you at each stage of the criminal prosecution, and you have the right to have an attorney represent you if you're questioned by law enforcement. If you cannot afford to hire an attorney, you can request to have the public defender's office appointed to represent you at the expense of the public. Do you understand that?
Yes.
Okay. Is he requesting public defense representation?
Yes, he is, Your Honor.
Okay, Ms. Cesario, you have the right to remain silent. Anything that you say, anything you put in writing can be used against you. You have the right to plead guilty. You can plead not guilty, or you can stand mute. If you stand mute, a plea of not guilty will be entered. You have the right in this matter to proceed to a trial. You have the right to a jury trial. You have the right to the presumption of innocence. So you're innocent until proven guilty. You have the right to have the prosecution prove your guilt by proving each of the elements of the charge being brought against you at a jury trial. You have to prove each element beyond a reasonable doubt. You have the right to remain silent at trial and not have silence be used against you. You have the right to see, hear, or question any other witnesses that the prosecution intends to call against you. You have the right to call your own witnesses or present evidence at trial that you believe would further a defense to this charge. Do you understand that?
Yes.
Do you have any questions about your rights so far?
No.
For the purposes of his arraignment, how is he pleading?
Not guilty, Your Honor.
The court will enter a plea of not guilty on your behalf. You're currently scheduled for a pre-trial before Judge Stacia Buchanan. It's going to be May 30th, 2023 at 10 o'clock in the morning. Did you get a notice to appear and her Zoom instructions?
Yes.
Okay. And you are able to appear via Zoom for that court appearance. Are you currently employed?
Uh-huh. Yes.
Where
I
is,
got work.
where is that?
I work at Vantage.
You
Android.
work where? Where?
Avantis.
What's your home address?
1925 West Holmes Road, apartment 10.
Is that where Ms. Solo resides?
Yeah, we live together, but I called police last night so she can get out the house. I don't want her there.
Oh, okay. Well, unfortunately, you can't go back there because she lives there, okay?
No, I'm on the lease. She's not on the lease. She gotta go. I live there. She don't live
You
there.
have to do a lawful eviction because you just told me she lives there.
Yeah, but she left last night with her kids.
How do you know that?
I pay rent down there. I was there
How do
when
you
she
know
left.
okay, you weren't taken into custody?
No, I was there when she left the house.
How did you get to jail if you weren't taken into custody?
You said what?
How did you get to jail if you were not taken into custody, sir? You weren't placed under arrest?
She called police on me, and when she called police, I was not home. But when I got home, I told her to leave the house, so I called police too.
Okay.
And,
Well,
they
the
arrested
records
me.
that I have, the records that the court has is that she resides at that property. Okay, and so you can't be there because she is there, okay? And so the presumption is that the law is going to issue orders to protect her as the alleged victim. If you believe she's unlawfully residing in your property, you would have to do a lawful eviction, okay?
Okay.
Okay, so as of right now, you can't go there because the records reflect that she lives there.
She's not on the lease though, so I don't understand.
I recognize that there's a lot of times people end up living places where they're not on the lease, but you let her live there without putting her on the lease.
Okay.
Where are you gonna live until you
Huh?
can reside? Where are you gonna live while this case is pending, sir?
My parent house,
Where's that?
2315 Ricedale Avenue, Lansing, Michigan, 48911.
What's your phone number?
517-619-9226.
Are you currently on probation or parole?
I'm on probation.
Before which court?
Eaton County, but they transfer my case to like Lansing, something like that.
Is that for the police officer resisting?
Mm-hmm.
Is that a yes?
Yes.
Okay. Can I have a bond motion at this time?
Thank you, Your Honor. Mr. Zarwia reports that he is currently on probation for an R&O charge, but otherwise has not been convicted of anything, certainly nothing of a violent nature. We understand the court's concerns for Ms. Zolo in this case and would certainly understand a GPS tether and or no contact order. But we're asking the court to consider that he has lived in Lansing his whole life. His kids are in Lansing, his parents are in Lansing, and that he is committed to and serious about resolving these matters. So we're asking the court to consider a personal recognizance bond for Mr. Zarwia in this matter.
The bond will be set in the amount of $500, personal recognizance with GPS tether and victim notification. While out on bond, if there's a no contact order in place protecting Nancy Solo, you're not to be within 1,500 feet of wherever she lives, works, or goes to school. Do you understand that?
Yes.
You have to have contact or communication. That's direct contact or indirect contact or third-party contact. Do you understand that?
Yeah.
So you can't have anybody else contact her on your behalf. You need to report to all of your court dates. You're not to possess a firearm or any other dangerous weapon. You're not to travel outside the state without prior approval of the court. You're not to use any alcohol or drugs without a prescription. You're not to engage in any assaultive or threatening behavior. You're not to be at the address of 1925 West Holmes, Apartment 10, as long as that's the address of Nancy Solo. Do you understand that?
Yeah.
Do you have any questions about your bond at this time?
I have a question about, like I live to the address. That's where all my stuff is. Like she left last night. Like, you know what I mean?
Okay, if
So-
the prosecution, once the prosecution verifies that she's no longer lawfully residing there, then we can change that order. But the information that the court has as of today is that she resides there.
So I have my, I don't know, like
You
I
can
got
go
my
once with
works-
law
I got
enforcement,
my
you can go
works-
one
I got
time.
my-
You
I
can
got
go
my
one
works.
time, you can go one time with law enforcement. They can accompany you to get your personal belongings, such as your clothes and things that you may need during the pendency of this matter, okay?
Okay,
Any other questions?
nah,
Nah,
No,
thank you. Any additional matters for the record?
Nothing further, Your Honor. Thank you.
Thank you, you're all set.
Your Honor, could I ask one quick question? What was the address he gave? He said he was going to stay at his parents' address. I didn't catch the street name.
It was Rydesdale?
Rydesdale. Okay. Thank you.
Mhm. Thank you, you're all set.
Thank you, Your Honor. Have a great day.
Same to you. We're on the record in the matter of Citibank versus Frank Nelson, file number 23-00159. Council appearance, please.
Yes, Bonayotis Marcellus on behalf of plaintiff, Citibank NA.
Okay, and then we have Mr. Nelson present in the court, correct?
Yes, ma'am.
Okay, Mr. Nelson.
I'm
we
sorry.
reset this- Oh, no problem. Mr. Nelson, we did reset this matter. I think you appeared after plaintiff's counsel had left last week. Plaintiff's counsel did appear last week with some information to clarify the appropriate redemption period. Did they go over that with you? Okay, did they? I thought you all met in a private meeting room today. No?
Yes, we.
Well, you didn't provide that information to him?
Your Honor, I basically advised, I didn't give him the specific dates, but if he likes specific dates, I could give it to him. I didn't give him the specific dates, but I advised him that I would be willing, because the problem is that the funds that he tendered were post sheriff sale. So that would either, it wasn't the redemption amount, so that's why they didn't take it. And so he did advise me that he did get, there was 2 checks that was sent to him. He did receive one of the checks, but the second check is still, he still hasn't received. I'm not sure why he's not receiving it. And so I told him I would, I give him my direct line and my assistant's direct line too, so we can figure out where that second check is. But those checks have been pursuant to my client's records had been tendered to. And so in an effort to help out Mr. Nelson, try to find alternate housing, we are willing to give the defendant till July 1st to find a new place to reside to.
Okay, well, Mr. Nelson is here, at least he brought this action or disputed this action because his concern was that he sent money that he believed would satisfy the redemption. And so you were supposed to look into that and advise him. And that's what I thought you all were doing in the breakout room.
Your Honor, I did advise him that those funds that he's tendered over were not enough to redeem the property. And maybe if at one point it would have been an amount to try to attempt to reinstate the loan before it went to foreclosure. But since after foreclosure, that was not enough to redeem the property, because the reinstate amount that passed after it went to sale. So
did you tell him what the redemption amount was?
The redemption amount would have been $41,412.68.
Did you hear that, sir? Okay, and so you understand that?
What I didn't understand, ma'am, was I didn't know it was going to a corner or,
For sheriff's sale, you mean?
yes.
Okay, so you didn't recognize that, but it did go to sale. Sounds like they did return one of the checks, and then there's another check that they're going to track down. Is that correct?
Yeah, because this one's almost a month old. And it just showed up this week.
The one that you just got this week?
It was dated 4/21, but I just got it.
Oh, okay. Okay, and so, Mr. Marcellus, you're gonna have your client look into where the other check is?
Yes, Your Honor. Since it took so long for the other check to get to Mr. Nelson, I told Mr. Nelson if he doesn't see it by the end of the week, to contact my assistant, or I give him my number too Monday, and we'll do our best to track it down. It's just alarming that it took so long for, you know, the one check, because it should have been dated April 21st. That
The
he
check
just
he
got
has in
it
his hand
last.
is dated. The check he has in his hand, he said is dated for April 21st.
Yeah, that's what my pursuant to my records too, is that check was sent out, was dated April 21st. And it's kind of alarming that it took that long to get to Mr. Nelson. So, and the other check, should have been dated April 14th. So, basically a week earlier. So
Okay.
that's
I'll allow
why
you all to-
let's just give it, I say give it, to the end of the week. And if he hasn't got it, then, we'll do some more tracking it down, Your Honor.
Okay, sounds good. So I don't see, sir, where you have any other, or any lawful reason to hold over the eviction any further. But they are being gracious enough to allow you into July 1st to vacate the property, okay? Okay, so you did file this motion to set aside possession judgment. I'm going to deny that motion because of the fact that possession was lawfully granted to the plaintiff, but we're going to amend the order to allow you to July 1st to vacate the property, okay? Do you have any questions at this time?
I know the first time I seen you, you wanted to know when they received my check, the first check,
Correct.
because it was a time limit, and I still had to turn it in. Yeah, I thought I turned it in time. Find out when they received the check.
They said they received it after your redemption period. And he provided that information at the last court date. That's why I thought he would have told you today. But the major issue though is the fact that, well, they returned that money because it wasn't a sufficient amount to satisfy the redemption amount. It's gone to sale. So what your belief is that you sent this in before it went to sale?
Yes.
Okay, I don't believe that's the case. When was the sale again, Mr. Marcellus?
The sale would have been,
Yeah, 28, 29 years.
It says it was October 27, 2022.
I believe that, yeah, that should be it, Your Honor.
Okay, and when did your client receive the
Actually,
check?
I'm sorry, on October 27, 2022, Your Honor.
That's what I said.
Oh,
When
I
did-
apologize.
when did you- No problem. When did your client receive the checks from him?
Those funds were received. Let's see. April 20th, 2020. One was received April 20th, 2023, and another one was April 10th,
So
2023.
this past April,
In April, Your Honor.
so the sale had already taken place.
Yes.
It would have needed to have been before that October date, okay, sir? Okay, and so hope that answers your question. Unfortunately, I'm not able to give you the relief that you're seeking. But at least they're gonna work with you to give you some time, understanding that you've been in this property for a while, to make arrangements for a new location, okay, sir?
Yes, ma'am.
Any additional questions? Any additional matters for the record, counsel?
No, Your Honor.
Okay, that's the order of the court. You're all set and good luck to you, okay, sir?
Thank you very much.
Thank you.
sir.
And Your Honor, should I just expect an order from the court, Your Honor, or do I need to do anything else?
Let's see here. Yeah, you'll receive an order from the court.
Okay, thank you, Your Honor. I appreciate it.
Thank you. Thank you. Motion to set aside production.